Hey, this is Brian Foley. I'm here with my partner Luis Baez. We're at Houston Criminal Defense Attorneys, and we handle federal cases. Today's topic is going to be about federal target letters. It's like the beginning of a case. Luis, you're our trial bureau chief and federal law expert. Can you tell us what is going on with a target letter? What is a target letter?
Yeah, so a target letter is essentially going to be a letter from the Department of Justice, whether you're in the Southern District of Texas, like the Houston area, or the Northern District of Texas, like Dallas, places like that. It's a letter from the Department of Justice, from Assistant United States Attorneys, prosecutors, federal prosecutors, to you saying, based on an investigation, based on work that's been done by law enforcement agencies, you may be the subject of forthcoming federal charges. One of the reasons why I wanted to talk to you about it was because we've gotten a bunch of calls recently for people who have been receiving target letters for things like, I'm sure you remember the Paycheck Protection Program from COVID, where people were applying for essentially interest free loans from the federal government. Well, it looks like they are turning on a lot of the investigations, sort of like going back and making sure no fraud was done. So we've been getting clients who've been calling about receiving target letters for that. I've also had a number of other target letters for things like Social Security fraud or Medicare fraud. But it's essentially a letter that says, hey, you might end up here in the near future with federal charges.
It's kind of like getting an audit letter from the IRS
It
saying,
is. It is definitely scary. You know, it's
uh,
in anything federal is always going to be something to take
boy,
extremely seriously. Yeah.
why is like what are the differences between like if you have to go to jail in a federal case versus a state case? What's the difference?
Yeah, so there is a huge difference between talking about, jail or confinement between a state case and a federal case. Typically speaking, when we say jail and we're talking about charges, we're talking about misdemeanors under Texas criminal law. So things like possession of marijuana, things like driving while intoxicated. When we're talking about a federal charge and federal charges, really the word jail is not at all in the picture. Instead, what we're talking about is prison, and we're talking about detention centers where you could possibly be detained on a federal case the entire time your case is pending, even if you have no criminal history at all, depending on what your federal charge is. And so the rules for confinement, the possible lengths of punishment, all of that is just exponentially bigger when we're talking about state cases and federal cases. So the target letter should be a signal to you, one way or another. Hey, I need to talk to a professional about the situation, as opposed to just walking into the local Department of Justice or the local offices by yourself to try and figure out what they're saying about you and whatever it is they think you're wrapped up in.
I hope people are not just walking into the Department of Justice after getting a target letter, but I can imagine sometimes it must happen sometimes. Um,
Yeah.
Definitely good advice to have an attorney before you start dealing with a federal charge. Um, so you mentioned detention, and you could be detained for the length of your case. In state cases, they have the bond system where you can bond out, and they'll have this hearing, and nobody's really there. Could you tell us what a federal detention hearing is at the beginning of a federal case?
Yeah, at the beginning of a federal case, any federal charge, the way it works is there's going to be an initial setting. Depending on the court you're in, it could be called different things, maybe an arraignment or an initial appearance. But when you are there, hopefully with an attorney, you actually will hear from and get to hear the prosecutor on your case talk to the court about what they want to do in terms of a bond or pretrial release. So if you are there in court and you hear the AUSA, the Assistant United States Attorney, or the prosecutor essentially say, we're moving for pretrial detention, then what that will do is initiate a process where there's going to be a hearing on whether or not pretrial detention will be applied to you in your case. It's kind of one of those things where in state cases there's kind of like an in between. Sometimes there's no bond, depending on your history, depending on the charge. Sometimes you can get out on what's called a pretrial release bond or a personal reconnaissance bond. Or you get a bond set, and it can be anywhere from like 5,000, 10,000, etc.
Mm-hmm.
In the federal system, it's really no bond or pretrial release, and that's how the situation and the rules play out. But there has to be a hearing if you're going to be detained while the case is pending.
So it seems like things go a little bit faster once they've decided to file a charge. But back to the target letters,
Yeah.
At the beginning, is it a guarantee that because you got a target letter, you're going to get charged, or can an attorney help you with that?
So the good news is, at least for some of the clients that we've had where they've received target letters, is it's not a guarantee that you will end up being charged. So just to back up a little bit, the target letter that clients have received is pretty detailed in terms of what specific part or what specific section of the United States Code they are trying to charge you with. So right away, they will let you know, this is what we are investigating you for. And typically speaking, the target letters will say you should try to hire an attorney. That way the attorney, your attorney, can reach out to the specific AUSA who sent you that target letter. And so at the very bottom of these letters, it'll have the name and contact information for the AUSA who is potentially prosecuting or at the very least investigating you for that specific charge that they mentioned. Now, I will say that the target letter is the beginning of the process. And to answer your question, because you get a target letter, it does not automatically mean that you will be charged. In fact, I would say that really what at least part of the intention of the target letters are for is it's the very first opportunity pre-charge for your attorney, a representative for you, to talk to the prosecutor on the case, which, correct me if I'm wrong, but that typically does not happen on a state level charge. They're either, they won't talk to you if you've got like a warrant or a pending investigation. This to me is pretty unique to federal law and federal criminal law.
Yeah, I agree. I think the federal prosecutors, they're a lot more involved at the beginning of a case and building a case. They have they call them reactive cases or proactive cases. Reactive cases meaning like, well, somebody went and robbed a bank and then we responded to the alarm. We've reacted as the police to this occurrence. Or proactive, that's like getting wiretaps, talking to people, giving somebody a target letter and saying, hey, give us this information and we're not going to charge you, but we're going to charge your boss, stuff like that. State prosecutors rarely have the opportunity to do that. The only time I ever encountered that, both when I was a prosecutor and as a defense attorney, is kind of drug cases. At the state level, they may run some drug cases with some informants. DPS will kind of do that on their own. But even then, the prosecutors are coming in at the end, not at the beginning like they will in a federal case.
Yeah, and like you said earlier, they may not want you, essentially, they may want your boss or something like that. So if you feel like you're in a situation where I'm getting this letter and it's kind of like, I don't think this is a specific legal term, but guilty by association. If you're reading a letter and you know what it's about based on the charge and you think, hey, this is one where I'm guilty by association, I didn't do anything outright or that's a specific criminal offense, sometimes the target letters are sent and the federal prosecutors know that, but they want to talk to you about, or your attorney rather, about what you know or what your involvement is. And so there have been times where really all the AUSA has wanted to hear from me is meet with your client, do investigation that you would want to do on your end. Just give me a call back and let's just talk about, assuming you want to have that conversation, just give me a call back and, I can get a better idea of your client's level of involvement or their level of not knowing what was going on whatsoever. And so we've had it where there are charges that just don't get filed on the client, even though at the very beginning it look like for a second, or they'll come in extremely worried about being charged. So I think what people really need to take away from this video, what they need to know about target letters is that A, it's not the end of the world. It doesn't mean that you are going to be charged. But B, it is something that I think requires an attorney, at least you reaching out to one. Fortunately, the letters are professional, and they'll say if you can't afford an attorney, you can come to the federal offices and try to get a court-appointed attorney. But we've had clients call us before, do consultations, and then we'll pick up the rest from there with the AUSA.
Mm-hmm. So on these target letters, when a federal prosecutor sends a target letter, again, that doesn't mean they're going to file the case. If they end up filing the case after that, is that when the detention hearing would take place?
Right. It would happen after an sort of an initial appearance, and then the prosecutors would announce, do we want to seek detention on this case or not? And that really sets off a whole other set of rules and sort of parameters to determine based on the charge and the punishment range and the client's history as to whether or not there's a thing called mandatory detention, or maybe it's more of a discretionary thing that the judge has the option to do. But if there is a charge, there will at least be one court setting. And at that court setting, you'll find out whether or not the federal prosecutors are seeking detention or mandatory detention from there while the case goes on.
Well, that sounds like a good topic for our next video, and a good time to end this one. Thanks, everybody, for watching in for federal target letters in Houston. I'm Brian Foley. This is Luis Baez. We're Houston Criminal Defense Attorneys, PLLC. Again, thanks for watching. If you like what you saw, don't forget to like and subscribe and hit the bell for notifications. As always, these are for educational purposes only. If you get one of these letters, don't just watch this video and go talk to them, right? Go get a lawyer and have a consultation. So thanks, everybody, for watching. We'll see you next time.